Welcome to our webinar today on the Eastern Neighborhood and Africa and Rule of Law Challenges, jointly organized by the World Justice Project and by Konrad Adenauer Foundation. My name is Caroline Löbrecht. I'm a program manager for democracy and sustainable development at the Multinational Development Policy Dialogue here in Brussels for Konrad Adenauer Foundation. And we are a bridge builder between the EU and the Global South. And we do that by looking at the nexus between democracy and development, but also climate policy and foreign and security policy. At CAS, we believe that there is no sustainable development without stable democracy, and there is no stable democracy without the rule of law. That's why we have 4 dedicated rule of law offices worldwide, one in Africa, one in Southeast Europe, and then one in Asia and one in Latin America, who really support the accessible justice and accountability worldwide in the regions. But of course, we also all know that the rule of law is currently on decline in most world regions. And this is not only due to Corona. And this is why our debate today is very timely, and we couldn't be happier to join up with the World Justice Project. Thank you for being our co-hosts. We're very much looking forward to the debate. A few remarks before we start on how we will do this webinar. We of course want it to be as interactive as possible. So we will right now, we will share 3 polling questions that we invite everyone to answer. And Jaya will later share the results with us before we start with the panel. Of course, there's also an opportunity for all of you to ask questions. Please, if you have a question to one of the panelists or to the whole panel, ask them through the question and answer feature here on Zoom. Please do not use the chat. You can use the chat if you have technical issues or if you need any kind of assistance, but if you want to submit a question for the question and answer session, please do that in the Q&A feature. And I will be reading them later to our panelists on your behalf. So it would be very helpful if all of you could also indicate whether their question is for one particular panelist or for the whole panel, and keep the questions brief so that we can really make sure that we can ask as many questions as possible. There will also be a recording of our today's session that will be shared both on World Justice Project's website later, but also on Konrad Adenauer Stiftung's social media channels. So once again, thank you everyone for joining us today. We're very excited for the debate, and I hand over to you, Ted. I think you're still on mute, Ted.
Good morning, good afternoon. I'm Ted Piccone, Chief Engagement Officer at the World Justice Project. Thank you very much for joining us. The poll questions are up on your screen, so please feel free to scroll through them and answer them. In the meantime, I will begin saying a few words about the World Justice Project and the work that we do to promote and measure rule of law around the world, and the efforts we're taking to support rule of law practitioners and defenders around the world. What I'm going to do is give you some slides of a PowerPoint presentation which summarize our latest rule of law index. This is work that we've been doing for almost a decade, which tries to track and measure the quality of the rule of law. And I will open that PowerPoint now. With luck, it will open. There we go. Great, I hope you can all see that. This is represents our
Ted, we can't see it.
Okay. Jaya, do you want to allow me to share the screen then?
You should be able to. Do you want to retry doing it?
Okay. How about now?
Yes, now we can see it.
Great. Sorry for that. So our index comes out every year, and this most recent version came out in March. And it is an effort to measure the rule of law based on 8 factors. And the first 4 factors up here on the screen: constraints on government powers, absence of corruption, open government, and fundamental rights, are really about steps, factors that try to constrain the power of government and ensure that individual rights are at the forefront. The second group, order and security, regulatory enforcement, civil justice, and criminal justice, are really aspects of state obligations, state responsibility to deliver justice to its citizens. And informal justice is another factor that we poll people on, but we don't formally include in the index numbers. Each of these factors have sub-factors, and this gives you a sense of the specificity of questions that are posed to those that we're interviewing. And in our database, you can really look into each of these sub-factors. What the index does is it is a comparative view of 128 countries and jurisdictions. And it involves 2 sources of data. One is household surveys. We've now reached over 130,000 households around the world. And expert surveys. Over 4,000 experts are reached for the purposes of this survey. And in all, it's over 500 variables. And we work on a sophisticated methodology to equalize and present this data in ways that people can compare across countries and across time. And just to underscore a basic point about why this matters, you know, rule of law and not just economic development, but other aspects of development, that the correlation is quite clear on the 2 points I have here: rule of law and GDP. Per capita, strong correlation. Countries with higher rule of law have higher GDP. And similarly on health. In this case, we're looking at infant mortality. And it is a striking correlation between rule of law and infant mortality. So let's look at the global insights from this last index. I'm also going to be referring to data we collected over the last 5 years. So to start with the positive picture, there's some improvements over last year's scores. And here's just a quick snapshot highlighting some of the countries that have performed better in the last year. You can look at a couple of examples in Europe and Africa in particular, and I'll go into a little more detail on that. In the picture here, these are the countries that are scored, have the biggest improvement and decline in their rule of law score. So you see a range, you know, a big jump for Ethiopia, 5.6%, and a worrying decline in other countries, Cameroon in particular, and Iran. This scatter plot looks at both 1-year and 5-year trends in the rule of law. This is annual percentage change in score for each country over the last year and over the last 5 years. And what to look at here is the bottom left corner is the largest grouping of countries in which 28 countries declined in the past year and declined in the past 5 years. So those are particularly negative trends. And if you look at the bottom right-hand side, countries that improved for the past year, but have nonetheless had a steady decline over the past 5 years. And here we look at the breakdown over the 8 factors. And you can see the number of countries that are both improving and declining. So on the positive side, if you look at regulatory enforcement, 64% of countries have improved over the last 5 years, compared to 28% that have declined. Or civil justice, where 50% have improved in the last year, while 40% of the countries have declined. But what's really striking is this next slide, in which the areas that have seen the most significant decline, both in the last year and in the last 5 years. And in particular, we see constraints on government powers, absence of corruption, and fundamental rights, which have really taken a hit over these past several years. And in the majority of countries, particularly, look at that score for fundamental rights. So there's no question that we're being faced with a public health crisis at a time when the rule of law is under significant stress. This map shows us over the past year declines in constraints on government powers. And if you look in the past year, very worrisome numbers from Poland and Hungary and Serbia and Bosnia. I don't think people will be surprised about that coming from Europe. Egypt is also of major concern on this front, as well as Cameroon, Cote d'Ivoire, and Senegal. And here is a closer focus on Europe. And you have a ranking of the countries within the European region and a spotlight on Poland and Hungary to give you a sense of the trends over the last 5 years and which countries are performing well and not so well. This map shows us more specifically in Eastern Europe, which we'll be talking about in the course of the day. Moldova has made some improvements according to the expert and polling surveys, and had the best improvement in this grouping, whereas Bosnia fell the most. And I'm sure we'll get to some of that in the conversation. We also wanted to look at Middle East and North Africa as a particular grouping. And here, Iran and Lebanon and Algeria are of great concern, while Tunisia is eking along in a more positive direction. Now, in Sub-Saharan Africa, we don't cover every single country, but this gives you a sense of performance there, improvements in Mauritania, Angola, and DRC. I mentioned Ethiopia previously, as well as Madagascar, and then concerns regarding Cameroon, Guinea, Mozambique, Mali, and Zambia. All of this information is available on our website. We have produced a new interactive data portal that allows you to look at each of these countries in more detail. You can compare them to the global rank, the regional rank, and income group, and see how they perform on each of the sub-factors. And it gives you a lot of opportunity to customize your research and analysis. We also have hard copies available. If anyone wants one, send us a note, and I think we will leave it there at that. And come back to the group. Jaya, are we ready to show the poll results?
Yes. So I just shared the poll results with everyone, but briefly to go over the results. About 48% of our attendees are working on government accountability, including election separation of powers. 35% are working on corruption, fraud, and integrity. 46% on opening government. The largest one was fundamental rights, for which people are working on. and then 50% half working on access to fair and impartial justice. On the second question regarding what measures governments have taken during COVID-19, 1/3 of our attendees said their government has used emergency powers to propose or approve controversial measures unrelated to the fight against COVID-19. 23% have adopted or enforced rules that limit the press and protection of journalists. 27% have had local or federal security forces act in a violent or abusive means. 23% or 21% have had the government infringe on the privacy rights of citizens. And 19% reported that the government has postponed or canceled elections outside the normal procedures. And for our last question, almost half of respondents said that institutional accountability, meaning enhancing transparency and improving anti-corruption efforts in judicial institutions, is the element they consider the most important in reforming and improving the justice sector. 35%, a little more than a third, said equal access to justice was the most important, and 17% said legal empowerment was the most important. Thank you everyone for voting. We're going to stop sharing the results on the screen, but we will post these results in the chat function.
Great. Thank you very much, Jaya, and I hope you'll peruse those results. We wanted to get a sense of what our audience is focused on and worried about to help inform the conversation that we will next have. I'm going to turn to our panelists from Moldova and Nigeria and start with Vladislav Hriptievschi, who is Executive Director of the Legal Resources Center in Moldova. His primary areas of expertise are in justice reform, reform of the Moldovan Prosecution Service, the Judiciary, civil procedures, criminal procedures. He's also worked on freedom of expression issues and handled strategic litigation before domestic and European courts. We will then turn to Kemi Okenyodo, Executive Director of Partners West Africa, Nigeria, working on rule of law empowerment, particularly focused on security and governance issues in Nigeria and West Africa. Her latest work is focused on police accountability, as well as security governance reform and election security management. We'll turn first to Vlad and ask him, give us a sense of how the pandemic is affecting your work in Moldova. We can't hear you.
Moment. Hello, I'm Vlad Hriptievschi. I'm coming from Moldova. It's a small country between Romania and Ukraine. And I'm leading a legal think tank called Legal Resources Center from Moldova. We're working on justice issues for more than a decade. And we have been surprised that Moldova scored so well in the rule of law index for this year, and perhaps there is an explanation for that. We had an oligarchic regime at power until June last year, and the government changed into a more promising one last summer, but that government didn't last that long, only 5 months. Perhaps this shift from November last year was not captured fully in the index, but this highlights one thing, that progress is highly unstable overall. Coming back to COVID, COVID added a new crisis to the existing democracy challenges in many countries from Eastern Europe. This crisis impacts our daily life, but it cannot suspend the democracy. Neither can put it at rest the rule of law and human rights. The truth is that the social networks have more influence on people than governments. And human rights and transparency blended with freedom of expression, genuine freedom of expression, give much more sustainable solutions than extreme measures often applied by the government. Otherwise, people will simply disregard the measures ordered by the government, and this will further erode the legitimacy of power. This will ultimately bring severe economic implications and many other negative consequences. The experience from my region confirms that we learn little from history or from brightest minds. A 2-month emergency order was introduced in my country, Moldova, on 17th of March. As a result, 60% of businesses closed. It is estimated that public revenues dropped by 60 to 70% without any reasoning. The parliament was not convoked for over a month, despite the critique of the opposition. The pro-Russian government from Moldova, disregarding the parliament, engaged in intransparent negotiations with the Russian Federation for a 200 million euro loan. This loan provided for a scheme of putting on Moldova the private debts of Moldovan companies in Russian banks, which are much bigger than the size of the loan. The leadership of the Broadcasting Council, which is the council called to ensure that the broadcasting regulations are in place and respected, called the journalists to stick to the official information when reporting about COVID crisis and stop operating with opinions of journalists in the news. The leadership, the more than 20 web pages were blocked by the intelligence service, allegedly for the reason that they spread false things, fake news about COVID. The time limitation for offering official public information of public interest was tripled from 15 to 45 days, making it practically impossible to obtain official information about COVID. The officials were delivering press conferences every day, but that press conferences didn't allow journalists to put questions, leaving space for a lot of speculations. An exception from the public acquisition system was introduced for COVID crisis procurements, making these transactions highly intransparent and feeding the rumors that contracts are assigned based on political interests. In the meantime, the president used the crisis to increase his chances to be re-elected in the next elections to take place in November this year. At the same time, the courts and prosecution offices practically suspended their activity, except for very urgent cases. A special procedure for dealing with complaints against decisions taken to combat COVID was instituted, which can be hardly called fair. It is true that the initiative of the government to access the Russian loan was blocked by the Constitutional Court, but its judges report that they were subject to pressure and called the prosecution office to investigate it. The prosecutors are still silent. The web pages closed by the intelligence service of Moldova were not the most influential ones, but it builds a highly dangerous precedent when the intelligence is blocking the web pages for an indefinite period of time without a clear justification and procedural safeguards against arbitrariness. I would like to come here to the recommendations we can deliver. COVID is not gone, for sure. We are certainly not at the beginning of the end. It's rather the end of the beginning, just. What can be done by the EU in the short term to preserve the rule of law and respect of human rights in Eastern Europe, at least, is first, to put strict conditionalities for financial assistance provided to the government. And these can be that the applied measures during the crisis are limited in time. And we all know that emergency measures often last much longer than the emergency itself. Second, is that measures are proportionate to the gravity of the crisis. Of course, the gravity of the crisis varies from one country to another, but there should be some logic between the measures taken and the public threat. The crisis cannot justify the limitations of the role of the parliament or of the opposition anyways. Any limitation of freedom of expression or information is hard to justify in times of crisis, because as highlighted before, social media compensate this deficit by speculations, and this damages the democracy. The challenges in ensuring effective access to justice can be mitigated via using digital tools, which are more and more used daily by people. Use of personal data for combating the crisis should be strictly monitored by independent bodies to prevent abusive interference with private life. And we have seen this in many countries. Keep the issue of rule of law and human rights on high-level political discussions with the governments. And also support the civil society and independent media in playing their role of a watchdog. Of course, these recommendations were made to EU, but these recommendations can be applied and are valid to a big extent to other big donors as well. What is clear for me, at least, is that the rhetoric, health or democracy and human rights, is unacceptable for me. We can have all of them at the same time. Thank you.
Great. Thank you very much, Vlad. That's quite a list of concerns and developments. It sounds like in Moldova, the environment has become really quite difficult for justice, democracy, and human rights actors. And I appreciate the specificity of your report, and it gives us a lot of challenges to think through. We're now going to turn south to Nigeria and ask Kemi to highlight concerns from her country. Kemi.
Good afternoon. I'm going to look at the issue from three to four broad areas. The first would be the human rights implications of the government response to the COVID-19 pandemic, and how this has played out with the law enforcement and security agencies. Then would look at the implication of this to the judiciary based on the directives given by the Chief Judge of the Federation. And then lastly, would look at the effect of this on the girl-child education, and then linking that to women's participation in decision-making process. So first, I think it was 29th of March that the directive for the initial lockdown was given by the president. And that was like a total lockdown. Focus states were Lagos, Ogun State, and the FCT. But however, other states took cue from this directive. And what we had was supposed to be a full lockdown, and the law enforcement agency, particularly the police, in the lead of enforcing the directive of the president. What we found was a scenario where, and I think the index raised that, on the arbitrary use of force by the law enforcement and security agencies in enforcing the directive of the president. So we saw not new, but always not a new scenario. But I guess one of the things I should state is that the response to COVID-19 has amplified the weaknesses in our institutions and in our framework within the country. So we had issues of extrajudicial killings, I would say indiscriminate use of force by the security and law enforcement agencies and some security agencies, which led to extrajudicial killings, pockets of extrajudicial killings across the country. We had scenarios of extortion by the security and law enforcement agencies. And if you permit me to say, if you widen the scope of that beyond the security and law enforcement agencies, we also saw an increase in sexual gender-based violence reports, complaints from members of the public. And if you link that to the response of the security and law enforcement agencies, because one of the directives from the IG laying on the directive from the president was that there should be no arrest except for serious offenses, and serious offenses are offenses that were not bailable. So we're talking about arrest could only be made in respect of homicide, terrorism, and such crime. So, and there was also a limitation or a restriction on members of the public visiting the police station. So you had a scenario where if you were a victim of sexual gender-based violence, who do you report to? How do you access law enforcement response? That was a challenge. Then if you link it to the issue of restriction of movement and essential services, we had a scenario where civil society organizations that work responding to sexual gender-based violence needed to lobby to get special passes to be accredited as essential service workers so that they could respond to challenges of sexual gender-based violence based on complaints that were coming in. We also had a scenario where the National Human Rights Commission was not seen as an essential service agency. So we're left out of the government parameters or framework that even made up the presidential task force for that was set in place to respond to the pandemic. This left a big gap, and of course the gap was seen as in the course of the implementation of the of directives by the president. When the National Human Rights Commission released a report sometime, I think April 15th, if I'm right, and they gave a breakdown of the number of complaints they had received. I think the first report the NHRC released, there was a statement made by the executive secretary of the NHRC that the numbers of citizens killed by the by police or law enforcement and security agencies were more than the casualties from COVID-19. And I guess that got the government worried. And then we saw a response of incorporating directives on human rights violations in the routine briefing to members of the public. But like I said, if it had been planned properly, the human rights angle ought to have been embedded from the beginning, and it ought not to be reactive. It could have been proactive and properly structured. Secondly, post the lifting of the relaxation or review of the restrictions, curfews were put in, a curfew is in place and it's still in place, 6 a.m. to 8 p.m. or 8 p.m. to 6 p.m., 8 p.m. to 6 a.m. So restricted movement within this period. And even before that, I think mobile courts were also put in place to arrest violators of the directives. What you had, again, for some of us within the community was like a joke, because then you ask, mobile courts are put in place, then what about the legal representation for the violators of the directive or the rules? Who defends them? And there was a joke among some of my colleagues that said, somebody called his lawyer saying, I've been arrested, I'm being taken to the police station, can you meet me there? And the lawyer was saying, I go there, can I also be arrested on my way there for violating the restriction to movement? Also because legal aid services was not seen as an essential service. So you query the definition of essential service to limiting it to public health, whereas public health built on what? Public health, rule of law at this point in time ought to cohabit. And when you get the definition wrong from the beginning, the strategy for implementing and responding to the issue would also be loop-sided. Then we looked at I'll look now briefly at the issue of girl-child education. And girl-child education, I mean, for most of us, we're familiar with the challenge of the educational system within the country, a weak educational system across the country. So let me first start from there. So we have students at home not accessing schools because the schools are off limit right now based on the restrictions. And there is a government, there is a directive that most schools should go virtual. And when you say most schools go virtual, the schools that are benefiting from this, they majorly are the private schools. The public schools are unable to benefit from this because the resources, the mechanisms are not there. So you have children across the country, primary school, secondary school, that are in limbo right now, are not benefiting, they are not going to school. Either virtual is not accessible to them. And then when you look at the process of even opening up the system, the possibility of opening up the system, and we look at social distancing, the question you ask for the public schools, how do you implement social distancing in public schools that have classrooms of about 50, 60 children? What is the plan of the government in addressing this? Not forgetting that the right to education is not a fundamental right, we say. It's non-justiciable. However, it is integral because when we look at the root causes of violent extremism across the country and the insurgency in the Northeast, lack of education is one of the root causes that has been identified. So how are we planning to address the issue of education post-COVID in the country? There needs to be a discussion around that and looking at what we have on ground and how can it be strengthened. We recently completed an assessment of area councils, 2 area councils in the FCT. And this assessment took place post the COVID. And looking at the reports, there are challenges. We noticed gaps with hygiene. So some of the schools do not have running water. And then we also link that to the issue of preventive measures. So if we say, wash your hands under clean running water for about 20 minutes, where is the running water coming from? Number one. Number two is you then ask the running water in the schools, is it made available in the communities where these children are coming from? So do they even have clean water to drink at home before we start talking about running water to wash their hands in school? There just seems to be a mismatch, you know, in what the response ought to be and the reality of what we find on ground and the directives or the recommendations, so to say, on how to handle this pandemic. And then, I mean, my school of thought is that the non-justiciable rights can be linked to the fundamental rights. So when the non-justiciable rights are lacking, then the fundamental rights will definitely be eroded. So definitely we're looking at the right to life not being protected because health, hygiene, education are a challenge. Finally, when we look, if we link this to the girl-child education, because we look at issues relating to women and girls within P1, that's our priority area. We know that some of the girls in some communities have used the school as an excuse to delay early marriage. But then we have a scenario where you do not know when the schools are going to open up. Are we going to see a scenario where the girl child is going to be married off before the system opens up? What mechanism is being put in place to protect these children, to protect these girls from early marriage? Nothing really I don't think much discussion is taking place around this. Then finally, when the presidential task force was set up, clearly missing on that committee was the Ministry of Women Affairs. And you ask yourself, why was the Ministry of Women Affairs sidelined from this committee? And I dare to say, same as the National Human Rights Commission, because the government has refused to see the value that the ministry brings on the table. Same with National Human Rights Commission, that they are cross-cutting government agencies that allows you to see things from the beginning to the end through a particular technical lens, and allows you to analyze and scenario building and come up with situations and responses that could come up when they are around the table and addressing and raising some of the fundamental issues. Finally, on the courts, my final comment on the courts is that the CJ, as I said, had directed that the courts should go virtual. It's for us in P1, it's a welcome development, because since 2016, we've been monitoring courts across the country, picking them in samples. And one of the things that have constantly come up in our report was the need for the courts to adopt technology. So now you find that the requirement to adopt technology is being foisted upon the courts right now. And the question you ask is, are the courts ready and capable to adapt technology? Because it goes beyond Zoom court sittings. We're talking about the filing system. We're talking about the filing system. We're talking about the litigation, the entire litigation prism. Even making your payments online and getting it acknowledged. So it's from the beginning to the end. The situation that takes place in the courtroom is like at the end of the chain. What takes place before the courtroom and ends in the courtroom is being left out. We had a scenario in-house when we had a discussion, I think some days back, that we had CJs signing up on this. And we were having some of the support staff in the courts pushing back on this. And they push back is just because they do not have the capacity to engage in this new dispensation. And of course, when you feel a bit threatened, the best thing for you to do is to shut it down at your own level. And because the level of accountability is weak, nobody is going to be held responsible. So our recommendation would be, let's dust some of the implementations or some of the projects that have taken place over time that were aimed at strengthening our judicial system, our court processes, and see if this is not the time to push for the implementation of some of this recommendation, because the system is obviously, everybody's vulnerable right now. You have to be seen to be responding to it, and you have to be seen to be having the interest of the citizens at heart. Next to that will be the vulnerable population. And for vulnerable population for us, when you talk legal empowerment and you talk legal education, then of course, naturally the basic education system comes into it. And the girl child is very key and critical to this. Do not forget that it's the girl child that later on becomes the mother. And research carried out some time ago when I was at in my previous life at Clean Foundation, it showed that the level of influence that the mothers of young people that joined Boko Haram had on their children was high. But it was a level of influence that people were not, we didn't pay attention to initially. So if that level of influence is high on the future generation, then it makes sense to invest in that, in this population, and ensure that they are well positioned to take their rightful place. Thank you.
Thank you. Thank you very much, Kemi, for that comprehensive assessment and analysis. It's really, for both speakers, a reminder that we're going from bad to worse on many categories of the rule of law. And that's what the pandemic is bringing to us. The system's under great stress. I think your point about technology is also well taken, that there might be an opportunity here to move courts and the legal services industry toward a more virtual arrangement, if that can enhance access to justice, that might be a good thing, but you do have to think about all the people who don't have access to technology. And your point about vulnerable populations is very well taken. Let's turn now to our second round of panelists to give us a bit of a donor perspective. I'm going to turn first to Jonathan van Meerbeke, who is a program officer with the European Commission's Development Cooperation Agency, focused on gender equality, human rights, and democratic governance. He's also spent many years working on European policy toward Africa, and previous to that as a migration expert. I will then turn to Andrew Solomon, who is a senior rule of law advisor with the US Agency for International Development and their Center of Excellence on Democracy, Rights, and Governance. Andrew has a tremendous amount of expertise on different issues on justice systems, access to justice, security sector reform, as well as transitional justice. So we'll turn first to Jonathan, and I think he has a PowerPoint presentation. And for people who are listening, please feel free to continue to add your questions in the Q&A box and try to identify the specific panelist because we will get to your questions after these presentations. Jonathan.
Thanks a lot, Ted. I will share my screen. I hope you can all see it now.
Yes.
Since I was told I had only 10 minutes, I thought maybe I may want to share also a few links to some relevant documents on our side, because there is a lot that we could say, of course, on what we do on rule of law, as you can imagine. First of all, I will talk maybe about what we do about rule of law, and then we'll go into the COVID response. First of all, why is it that we work on rule of law? I mean, I must say it is actually a legal obligation on our side. It is one of the core fundamental values of the EU, together with democracy and human rights. And we have actually an obligation to, it's also an objective under our external cooperation. So we have an obligation to work on it under the Charter of Fundamental Rights, the EU Treaty as well. And fairly so, because as you mentioned, I remember your graph that you presented at the beginning about the correlation between rule of law and health and development. For us, it's very clear that rule of law underpins all that. So it underpins all the other SDGs. So if we work on that, then it will allow us then to move ahead on all other development objectives. What is it? So in which framework do we operate? Sorry, I invite you, if you are interested, to look at our last proposal that we published in March for the next action plan on human rights and democracy, which is our policy framework for the next 5 years. An interesting feature is that we propose now for decisions among the EU decisions to be taken at qualified majority voting and not anymore unanimously. So hopefully it will also improve, and it will make it more smooth as well for us to operate in that field, because we won't need unanimity anymore from all the member states. In terms of our policy framework, it depends on the regions. We have a very strong, as you can imagine, dialogue with the enlargement countries, countries who are willing to join the EU, with a very strong leverage, because if they have to abide by our standards if they want to join the EU. So there, of course, we invest heavily on those countries, and we also invest a lot on the so-called neighborhood countries, which are countries with most of them we usually have specific agreements, association agreements that encompass, of course, trades, developments. Significant funding. We have rule of law operations and programs in pretty much all of those countries, most of them. It is a major priority for us. So you have Northern Africa, Middle East, Eastern Europe, mainly Balkan countries that are all part of this neighborhood policy. Including those countries willing to join the EU. For Africa, we have the so-called Cotonou Agreement with African, Caribbean, and Pacific. So we have also a framework there with also clear provisions on rule of law. For instance, the obligation, to join the International Criminal Court is in there as well. It is now being renegotiated for the next period. There will be a summit in October with African countries for the Africa pillar of it as part of the Africa strategy. Here also you can look at our priorities in the communication we just adopted in March. And these policy frameworks allow us for a political dialogue, of course, at bilateral level with each and every of those countries. And it's in that framework that we also operate. Sorry, how do I get there? Here we are. In terms of our cooperation, what is probably, I think, the most relevant tool for us really is the conditionality of our support. So there is actually a contractual obligation to respect fundamental values. That means that if there is a breach of rule of law, I mean, a serious breach of fundamental values, I mean, human rights, democracy, rule of law, we're entitled to suspend our cooperation. We have what we call the risk management framework, where we assess human rights, democracy, rule of law. So we use the indicators from the World Justice Project, the index, from others as well. We do a thorough analysis every time we need to make a payment to a country to look at that, and it gives us then it's an extremely useful tool whenever we have a policy dialogue with the partner countries. In particular, in those countries where the support is significant. Of course, in countries where our support is not that significant, then you can see that that's, of course, we don't have the same leverage. Obviously, if I take Moldova as an example, because we've been talking about it, there, for instance, we've had exchange of letters where we have requested some goals to be attained for our next payment. In terms of reforms for the judiciary, we ask for a strategy to reform the judiciary. We've been also asking to review rules on nominations. I just want to make sure that I'm not getting it wrong. Sorry, for the members of the Superior Council of Magistracy. We have also requested some anti-corruption rules, for instance, to set up this joint investigation team on this bank fraud from 2014. Also on media, Vladislav was mentioning that we have also requested an audit of the Audiovisual Council. So you see, we make those payments dependent on some strong conditions. We have also incentives, in particular in the neighborhoods, for those countries that are performing well, so to receive additional funding. Then we have the cooperation projects on governance per se and rule of law. We've had it in about 70 countries, bilateral programs over the past 7 years. There, of course, justice obviously is at the core of it, justice reforms. We look at, of course, independent, strong and efficient independent justice systems. We look also very much on the receiving end of it, so it has to be, of course, centered on the people, very important for us. But it's also usually very often part of a wider program on governance that include also democracy, human rights, stability, support to a security sector reform, for instance. So it's not always only specifically targeted on the judiciary. We like it to be also part of a wider program if it can be the case. And whenever we can actually work well with the government or not, there is always very often cooperation with civil society, because we think that civil society actors are extremely important in that process. Also oversight bodies, thinking of Supreme Courts, parliaments, and so on and so forth. I mean, when we talk about rule of law, of course, you look much beyond the judiciary per se. There was an example that I mentioned there. You can look at it as well for Nigeria if you want, where we saw there was a political will to work on corruption, and we decided to set up a 25 million euros program with the government with several strengths. We work with the judiciary on reforming the criminal system. We look in particular at the most vulnerable people, for instance, victims of sexual violence. There is also a component working with anti-corruption agencies, another component also working with NGOs and civil society as well. But feel free to give it a look. It's an interesting one, I should say. Then there is, of course, cooperation at multilateral level, extremely important for us. So we support all the mechanisms at the UN level, the ICC. We support the regional mechanisms, thinking of the African Commission on Human Rights, African Court on Human Rights. We work a lot with the Council of Europe and the OSCE, very useful, of course, in the neighborhoods. Countries. And then I just want to mention as well, we have, of course, a different approach depending on the level of the country, of development of the country. So, of course, in post-conflict context, in fragile countries, it is slightly different. It's part of an approach on transitional justice, which is, of course, adapted to the needs of the country, including criminal justice, fight against impunity, but, of course, reconstruction and so on and so forth. If you're interested, you can look, it is publicly available, the evaluation of our past support in the neighborhoods. I think probably the main lesson learned is political will and ownership. I mean, we can invest a lot of money, for instance, into a new case management system. If there is reluctance from judiciary, it will not work. Huh? So that's something we've seen clearly. I mean, in that field of operation, you need there is a lot of reluctance from the judiciary, from the executive. So you need to have very strong political will from the highest level if you really want to achieve any meaningful change. In terms of COVID response, like most of the donors, of course, we first attend at the health and humanitarian crisis, the socio-economic consequences of it as well. We have developed a big package of funds, emergency response. We were talking about that, and budget support, macro-financial assistance as well. And there you can see, of course, you can sense then the difficulty when we talk about that, because if I take again the example of Moldova, for instance, it's a country that asked us to front load payments to face the crisis. On the other hand, we tell them, and they also tell us, look, we need to, so we cannot implement all those reforms that you ask us for because of the situation. So on our side, we said, look, you need to move ahead with your reforms. But on the other hand, there will be a new macro financial assistance package of 100 million euros. So you can see here, it's about the lesser evil. It's okay, we need on the one hand to attend the humanitarian crisis. The government needs this money. So how do we then see the conditionality parts of it, conditionality and on rule of law? Do we want to be strict on it or not? So it's an ongoing, of course, as you can imagine, dialogue at very high level with those governments, and also, of course, internally to assess how we go about this. We monitor the situation. I like very much that slide from Videma. Well, I like it, but it shows at least those countries that are most at risk of democratic backsliding. So we look very much at the data and the trackers produced by VDEM, by INCL, the Economic Intelligence Units, Transparency International, Justice Project. So we follow the situation very closely. We are extremely worried. I can tell you, you heard some, I think the examples from Moldova and Nigeria were extremely compelling. We really think, I mean, the question really is, okay, so when will these emergency measures end? That's something we are monitoring very closely together with other donors as well. Of course, we meet with our member states every week virtually to discuss. We meet with OECD donors, other donors. We have discussions with World Bank, IMF. So all this is ongoing. And there is, of course, a lot of worries, in particular, because when I look at your initial presentation, we see that it's in those fields where we see clearly a backsliding, fundamental freedoms, right to privacy, rights to assembly. It's also looking, of course, at constraints on government powers, corruption as well, where we see the highest risks. So we have a number of measures that we will be adopting. So we, of course, have recommendations from all our delegations in all the countries we work with. We have a number of recommendations for them. On corruption, we have clear mitigating measures. So whenever there is EU funding involved in terms of transparency, in terms of audit, whenever there is emergency procurement. So that is something that we are looking very closely at. We have, of course, the public diplomacy, the political dialogue with the government. We have specific mechanisms to support human rights offenders, individuals. We have also simplified procedures to contract quickly with NGOs. Also, we are now discussing, for instance, a contract to support media, for instance, in several countries. We look specifically at vulnerable groups in new actions that we are trying to fast track. If I give an example, the Spotlight Initiative, you may have heard of, which is a flagship initiative of the EU together with the UN to fight violence against women and girls. And here we have an additional 9 million euros, for instance, for 44 women organizations in Africa to keep doing their work that they do in those countries. Then finally, in terms of response, when I look forward-looking, of course, looking at the situation after the crisis, we know it will be a very different world. The situation, of course, there will be much more fragility in this country. So that means we need to adapt our thinking, because we are now currently in the programming phase of the EU funds for 2021-2028. So our delegations in the countries are consulting with the government, with civil society. They are preparing our priorities First, it's very clear that we need to prioritize good governance, rule of law, whenever we can. So whenever it is possible, whenever we see that there is an openness to work on those. There was this whole discussion on triggering political commitments, the stick and the carrots. So the conditionalities, the incentives, the political dialogue. We use all our tools to be able to really to attain our objectives. In terms of approach, very important, of course, to have a very good diagnostic of the situation, to have a very holistic approach centered on the people. We have this so-called rights-based approach that we develop in all our projects. Reach beyond institutions, as I mentioned, very important. So we will keep working with civil society. We have a dedicated instrument for that, and that will continue beyond, of course, the approval of the states, and that will certainly continue. So in short, that's the main point I want to make, and I'm happy to answer to any questions you may have. Thank you.
You're on mute, Ted.
Okay, can you hear me now? I apologize. I was just saying, Jonathan, thank you for that very comprehensive approach. It's interesting to see the tension between the short-term urgency of responding to immediate needs and the longer-term challenges, and the way conditionality has to play into that conversation. It'll be important to elaborate a little bit more as we go on with the conversation. But let's turn to Andrew to get a perspective from Washington and USAID. Andrew.
Thanks, Ted. Just a quick radio check that you can hear me okay.
Yeah.
Okay, super. One quick point regarding the index I'd like to start with. Many of us at USAID, myself included, rely upon the index in the design and the implementation of rule of law programs in a variety of countries. So I really just wanted to affirm that the index and the other data and analytical resources that WJP and other actors are providing is really essential for how we do this work, and frankly, to help us do it better by making it more data-driven. So yes, it's a valuable resource for donors as well as the governments, the justice sector institutions, and I also believe civil society, which in addition to doing oversight and evaluating performance, can really drive innovation with some of the data that you're generating. I'll dispense with some of my preliminary remarks. They've been covered by others, but I do want to outline what we see at USAID in our efforts to promote the rule of law in regions around the world, including in Africa and Europe. And in these regions, what we see, as we do across the globe, is a variety of rule of law problem sets. And these problem sets include, first, a significant justice gap with millions, if not billions, of people who are estranged from the law. They can't use it in their daily lives to resolve that legal problem, often in civil and administrative matters, and we have the data on that. Second, we see crime, violence, and insecurity still plaguing many countries and communities. And this is accompanied by that prevailing sense of impunity. No accountability for perpetrators, no justice for the victims. Third, and this has sort of come out as well in some of the other presentations, judicial independence and self-governance remain a real work in progress. Additional efforts are needed to strengthen the powers of the judiciary, to support a genuine system of checks and balances, and to provide that horizontal accountability that's so fundamental to rule of law and good governance. And then fourth, the last problem set is it's related to public trust and confidence in both justice and security institutions, which remains low in many countries. And we have lots of data on that. And the reasons are many, but this lack of trust tends to stem from the inability of these institutions to meet the needs of the citizens and the communities that they're mandated to serve. Unfortunately, many justice systems and security systems are just not performing. So in recent years, USAID's rule of law activities have largely been oriented around solving these problem sets and the related issues. And as I think we all now know, we've established that COVID-19 is a game changer. It has exacerbated these existing rule of law problem sets, as we've heard my fellow panelists describe. And at the same time, it's also giving rise to a new terrain of challenges that we're really trying to understand and begin thinking through how to respond. So like other actors in the space, USAID quickly recognized that COVID is not just a global health crisis, but it also has economic, social, and political dimension. And it's definitely presenting a crisis of rule of law and justice. So in early April, my office, the Center for Democracy, Rights, and Governance in Washington, developed a white paper to inform USAID strategies and programming for COVID-19 response. And I'm not sure if we can share that in the chat box, but it is available on the USAID website. You can Google it. But with regards to the specific rule of law and justice response activities, this white paper addresses in no particular order, and again, reflecting what we have been addressing today. First, really the need to ensure the legality of and prevent the abuse of public emergency powers, the lockdowns, the curfews, with regards to protecting fundamental rights and freedoms, as well as judicial independence. And I think Kemi began to get into that issue. Second, we see the need to mitigate the disruption of court operations and legal services on account of the physical distancing requirements. So that brings in the digital or the remote hearings. But there's other creative and innovative ways that have been experimented with or otherwise used as part of their existing systems. So we're also looking at the need to protect the health and the safety of those deprived of their liberty, those in detention. And I haven't heard too much about that, but that is indeed a significant implication by COVID, and the need to release nonviolent offenders who are in detention facilities, not just out of concern for their own health and safety and their fundamental rights, but out of concern for the personnel within current facilities. And likewise, we need to be concerned about the health of all frontline justice providers. And then lastly, we're really stressing the need to address those immediate COVID-19 related legal and justice needs of individuals and communities, particularly those of women, the poor, and other key populations. And here it's the domestic violence, it's the discrimination and stigma, the denial of access to services, including health services, and evictions, and housing issues. Now, in terms of some of our actual assistance programs and activities, what we call the COVID pivot, and how our programs and our partners are moving from their long-standing work objectives to address COVID-specific. It takes a variety of forms, and I'll just highlight briefly some of the examples of how our partners with USAID support are making that pivot in both Africa and Europe. And I'll start with Africa. In Liberia, we're supporting the National Bar Association there, who is now providing pro bono legal aid through their legal aid centers to decongest the detention facilities in order to prevent the spread of the virus. So legal aid lawyers are actually working to have pretrial detainees accused of nonviolent crimes released by court order. In Morocco, on the security side, we're working with police commanders in providing safety trainings so that they can brief line officers on public health protocols and good practices for how they interact with the public and how they should, where necessary, make arrests and investigate crime scenes, with regards not only to the rights of citizens and individuals, but also, with regard to just good practice with health. In Rwanda, through our program there on access to justice, civil society organizations are developing the public service announcements, producing radio talk shows as a way of disseminating information to the public during this time, particularly with regards to how to avail themselves of newly established telephone hotlines to access legal advice while they're on quarantine, and on other means to contact paralegals with complaints during the lockdown. And a lot of this effort is also being directed to those in detention, whereas before social distancing, our programs were actually able to physically engage and go to detention centers, but now that's a big challenge with lack of access. So how do we reach these populations with the concerns of physical distancing? And then in Ethiopia, we're working with the Supreme Court there on the technology side to conduct remote hearings and video conferencing. So we're building that infrastructure for them to continue operations. In Europe and Eurasia, specifically in Georgia, we're working with the High Council of Justice there. They've convened a working group like we see in other countries, but it's the High Council of Justice really driving a working group that involves the Ministry of Justice, prosecutors, the bar, to begin elaborating what are the procedures and the standards for digital hearings and also electronic case filings. And at the same time, we're supporting civil society organizations on the sort of side of the equation, and so that they're able to quickly mobilize and monitor the work of the courts in this new mode, this electronic mode. In Kosovo, the Kosovo Judicial Council actually drafted an emergency preparedness plan to guide its decisions and the work during this COVID. It's a plan which was not really there. An emergency preparedness and response plan had not been in place, but now one is being developed, not just for this one, but it'll serve them in the future should other emergencies arise. And at the same time, we're having to work at the court level and the court action plans to actually begin foreseeing how to deal with the future backlogs resulting from the limitations of hearings during the pandemic. So, reducing court backlogs is a challenge for judiciaries in so many countries around the world in just sort of normal non-COVID times. But, now we're seeing with the reduction of court operations, there's likely going to be a considerable backlog that's going to have to be addressed. And then just in Moldova, the court automation and the infrastructure investments that donors have made have really enabled the courts to continue operations with regard to hearings on detention-related issues and other civil cases that can't be suspended. And on this point, we talk a lot about resiliency in the world of development, and I think this is, an example where the investments that are made in court automation, and while expensive and complicated, and where they begin to actually take root, we see that courts or justice institutions have this resiliency to deal with these shocks. So I think that's a positive. And similarly, in Ukraine, we're working there with the National School of Judges. They've shifted to a virtual platform to really address or help judges, understand their role in a pandemic. They're looking at techniques for successful online dispute resolution, and also addressing basic wellness and mindfulness of court personnel and other frontline justice providers. So I'll just wrap up with a few thoughts about more long-term post-COVID-19 reforms. I think, as others have mentioned, the virus has really, in many ways, been a stress test for justice systems and institutions around the world. And what it has revealed, as I've heard one practitioner on one of these large global events say, is that COVID-19 is a 21st century global pandemic colliding with a largely 19th century justice system. And that what we see in many countries, not all, but in many, justice systems and judiciaries around the world, they're still very much paper-based. There's other procedural and administrative processes that create inefficiencies. And many of these institutions are conservative. They're highly formalistic, legalistic, and resistant to change and innovation. But as that proverb goes, necessity is often the mother of invention. And we have seen, and we've heard today, how COVID-19, the lockdowns, the social distancing, has really forced some fundamental change in a matter of weeks, and in some cases in a matter of days, particularly in court operations and legal services. So I really think the question for us as reformers, as donors, as practitioners, is, do we return to the old methods, to the old normal, or are we going to create a new normal, one that sustains and builds upon the recent innovations in order to fundamentally transform justice? And I know there's been a lot of effort here recently about people-centered justice. I think that's a part of it. But to answer that question, I think we do need to invest in the monitoring and the evaluation of these new approaches, the new procedures, and the new practices where they have been introduced and are being used. Are they really working? Are they serving the interests of justice? Are in virtual trials, is it virtual justice? Because is there a lack of defense representation, and are the due process safeguards there weakened? And if they are working, and if they are successful, then how do we begin taking them to scale and to make them sustainable? I think that's the fundamental challenge that we face. And then just very briefly, a couple quick other points. We also need to plan, and I think we're trying to do that, for the future justice terrain. We need to anticipate the legal problems that will arise over the long term. Not only how do we bring the public emergencies to an end, following principles of legality, but what will be the legal problems that are there? Employment issues, consumer debt, bankruptcy, the economic shock to individuals and to the private sector is significant. And related, the massive spending that states are making to keep their economies functioning and to deal with those immediate shocks from COVID on the social and economic side. I'm concerned that this could lead to a decrease in judicial budgets and funding over the long term. So I think, again, as reformers, we're going to really have to make the case for why the judiciary, why the justice system, why respecting fundamental rights are essential to the recovery and addressing the social and the economic implications of this pandemic. And again, I bring it back to the data that WJP and others are generating. I think the data is in many ways the key for how we make this case. So I'll just leave it there. I look forward to your questions.
Great. Great. Thank you, Andrew and Jonathan, for those comprehensive presentations addressing both the short and the medium and the long-term challenges that are posed by this pandemic. Also comes to mind a cliche about in every crisis is an opportunity, and this may be an opportunity to generate the political will and expose the underlying root causes of so many of these justice problems and the interrelationship, the point Kemi made, between the fundamental, issues of right to education and public health and right to life, and how these things have to be joined up in a much more fundamental way. Let's turn to our Q&A portion. We don't have that much time, we have about 10 minutes, but turn to Carolyn to see if she's had a chance to identify a few questions for the panelists.
Yes, definitely. Well, first of all, let me thank everyone who submitted questions. We actually have quite a few, and we hope to answer as many of them as possible. But if your question is not answered today, please don't hesitate to reach out to us after. We try our best. There were actually quite a few questions that were wondering about how the rule of law is adapted in EU programming, for example. So I'm going to go to you, Jonathan, and ask you two questions pretty much. So the first question would be, how does the EU integrate freedom of expression and the right to information in its rule of law program and emergency assistance funding? And the second question would be, I'm just putting out both so that we can combine, you can combine them in your answer. The second question would be, how is SDG 16.3, so the right to promote the rule of law and at national and international level, how has it been used in both EU internal thinking and rule of law programming, and at the same time, how has it been used in the EU exchanges with African governments?
Thanks a lot, Caroline. For those interested, I shared a few links also by answering to the question in writing as well, so you can look at that. On freedom of expression and access to information, it is obviously a growing concern. I think now we're taking it extremely seriously. The External Action Service, in particular of the EU, also now is a dedicated team working on that. And in terms of cooperation as well, we've seen a growing number of projects and programs targeting specifically the issue of media, for instance. We have guidelines that date back to 2014. I send you the link there, but I think they're still extremely valid. And we very much see, in particular now we see it with the COVID situation, that it is in particular because we see also a shrinking space for civil society to operate as well. So it's something that we systematically address in our political dialogue with governments. We have dialogues on human rights with all our partner governments, and something that we systematically share there. And of course, also through our direct support to civil society, which is of course not always appreciated by the government, but something that we do anyhow. To your second question on SDG 16.3, I think you were mentioning how it has maybe changed the way we see things. I think what has been very telling, and there if you look at the work of the Justice for All Task Force, is that actually we now realize that we will not reach that goal if we just do business as usual, because very often the formal justice systems are not designed, and I see also the comment and from the colleague from Nigeria, Ibrahim, as well, on the need to work also with informal justice systems as well. I mean, basically people don't trust very often the formal justice systems, so it's not adapted as well. So we realize now that we need more innovative ways of addressing the justice needs of the people beyond the more traditional support to the justice institutions, I would say. So there is now some creative thinking that is ongoing on how we reflect that then in our programming for the next phase, on how we can expand concretely the support to the people with this people-centered approach, which I think now is also something that we learned from the SDG 16.3. On the internal EU issues and affairs, I think it's a slightly different story. I think it's more, we look more at how the situation is evolving in some countries, worries that we have, and how we are reacting to that, looking more at our own, the EU treaty, at the EU Charter of Fundamental Rights, the role of the European Court of Justice. So I would say that here we have much more specific, let's say, regulations that we have to abide to, and fundamental rules that we are looking into, and concerns that is more, let's say, turned towards the internal to the EU, with mechanisms in place that we are activating as well. So it is somehow different story, I would say.
Thank you. Yes, we had quite a few people actually who were wondering about the role of civil society, and I'm going to put that out to the panel. Maybe Kemi, we start with you, because people are asking, what can civil society do right now? What can civil society do to respond to COVID-19 and hold governments accountable for public health failings when their civil rights and their political rights are curtailed at the moment?
I think engagement for civil society organizations can come both ways, and I usually define them demand supply side. So demand side is the side we're very used to, which is the issue of monitoring documentation of violations or lapses or gaps on the part of government, and documenting this, putting this in the public space, holding dialogues in order to hold them accountable. But then my school of thought is, to what aim and purpose? What's the end objective of that engagement? So you look at the other side, which is the supply side. Could it be that what we see as violations are as a result of systemic failures and challenges and gaps on the inside trail? If we are able to work with government to do an assessment of the system and identify where the gaps are on the inside trail, and work with them in closing those gaps and strengthening the framework, and then also have a periodic review mechanism of seeing how effective that new system being put in place is working. Of course, still working with colleagues that have the mandate and the strength to monitor and document. Then you look at the policy environment. Do we need a review or a retweak of our policy environment? Then you have actions that can be taken at that level, either the policy or the legal framework. For example, I can speak to us here in Nigeria. It's I'm looking at our policing reform process. In this age and time, we've been on the review of the police bill since 2004, if I'm correct. The Nigerian Police Force Reform Bill has been at the National Assembly since 2004. In 2020, it's more imperative now than before that we review the legal framework that the police operate with and ensure that it's strengthened, it's fit for purpose, and also the accountability process, looking at the accountability mechanisms. So it's not to jettison it, and at the heart of that is one of the, Andrew raised this. There was a decision, and it was a policy decision, of decongesting the correctional services cell. Is that going to be an ongoing process, or was it a one-off thing? What was the criteria that was used in determining who were released? I'm not sure it's so clear. And also looking at the corruption and the manipulation that takes place, that we're aware that takes place in identifying detainees that make their way onto the list before the pandemic. So now with the pandemic in place, who's looking at that? To not just for us to be satisfied with 230 people released from prison. Who were the 230? Were they those that had already been convicted? Because our challenge is not with those that have already been convicted serving time. Our challenge is with pretrial detainees. They form like the 60% of the population in the prisons. So is it that population that is being targeted? So I'll say that, there's enough work for us to do if we look at it critically and see where we can engage and where we have the strength to engage.
And allow me to extend the question to Vlad as well, because I think it might be a similar picture in Moldova.
Well, First, I don't think that the methods of operation of NGOs change over crisis. On the contrary, we should intensify our efforts. Monitoring and reporting on human rights violations is one thing. What we also discovered is that in the times of crisis, as Ted rightly mentioned, there are also plenty of opportunities to improve the system. We've noticed that lately, due to the fact that the resources of the governments are directed towards other directions, there is some openness of the government for technical assistance as well in the field of putting in place a better legislation for respecting human rights and independence of judiciary.
Great, thank you. Maybe one last question, because we're already running out of time, but we have so many interesting inputs. I'm putting it to both of the donors, so Andrew and Jonathan. A lot of people have asked, on the one hand, how the EU has really changed its approach in responding to COVID and the rule of law failings that happen in a lot of countries. Yeah, a lot of people have stressed that there's a lack of accountability from political leaders. So the question, I guess, to both of you is, how can donors work with governments in this crisis, and has the approach somehow been adapted to the crisis?
Andrew, if you want me to start, happy to do so.
Yeah,
I mean, we are still now reacting. Yeah? So we are still in a phase where we are, as I was mentioning, reacting now to the most pressing needs. But it is very clear. I mean, we're entering. It's actually it's a coincidence, but it's also now a phase where we are developing our strategies for the next 7 years in our cooperation in a given country. So we are currently engaging with the government anyhow on priorities for cooperation, and that gives us a leverage, of course, the leverage that we have from development aid. That is one thing. Of course, we have more leverage in terms of political and policy dialogue with many of those countries with whom we have trade relationship as well. So we have, of course, in each and every, I mean, our ambassadors also who are discussing with the government. And if I take an example, because we have a colleague also from Ethiopia, for instance, in a country where we've been investing a lot with many other donors on elections, for instance, that are being postponed. Well, then we need, of course, to analyze how it impacts our work with or support the government on the whole electoral process and on the democracy as a whole. Of course, it has an impact on the way we cooperate with the government. But it's something that we need to reassess in each and every individual program, let's say, and in cooperation with the government and with the donors. I would say on the spot, see how we best adapt our cooperation. We may have to suspend some cooperation. We may have to threaten to suspend maybe sometimes. So there will be also this game that we'll be playing of. I think it's part of it. What is very important in any case is to engage. In many countries, we have the ambassadors, all the EU ambassadors, for instance, meeting together, making statements, reaching out to the government to raise concerns. And of course, then it's not the EU. We are talking about the EU as an institution, the Commission anymore, but we are talking about the EU, including the member states. And then, of course, it becomes something. Because you have Germany, you have France, you have all the most prominent member states as well, with many interests in those countries, and vice versa, joining in as well. And of course, when we are together on this, including other donors as well, of course, it certainly makes a difference.
I would just add very briefly that I think in order to beat the pandemic, to address both the immediate needs in terms of response and then build to recovery, it is going to take partnerships, and whether it's at the bilateral level, and we are constantly, engaging in those dialogues, government to government, USAID mission to counterparts in the country, So those bilateral partnerships are key. It's the multilateral partnerships. So just as we heard Jonathan say, you know, the donor coordination is going to be essential. It always is, but this is an even more pronounced. And then partnerships between the donors, the host governments, civil society, and then also private sector is another one that we haven't really talked about. So I would just answer it that way, is that we have to keep in mind, we beat this through the partnerships, and they have to be multidimensional.
Great. Well, I think it just leaves it to me to finish and wrap up our program. First of all, thank you all for joining us. We had over 130 people from all over the world be part of this conversation. And it really shows technology can bring us all together in some new and important ways, and we can learn from each other. I learned a great deal from all of our speakers. So thank you for joining us. Thank you to our panelists for taking the time to prepare the remarks. I think this is just a start of a conversation. As Vlad said, this is the end of the beginning. There is a huge, long road ahead of us. And there's incredible challenges in front of us in terms of governance and justice. And this will help identify the priorities, matching together what's happening on the ground in the field with the donor strategies and making sure they're all talking to each other. So I hope we played a part in that conversation. We will have this recording available on our website in a couple of days. So we'll circulate it to everyone who registered, and please circulate it beyond that to your peers and colleagues. And we will also be producing additional material on how the rule of law space is being affected by the pandemic. And we hope you'll keep in touch with us and register for our updates online. And I think with that, I'm going to sign off and thank you all again.